Members, this is the appointed time. We have a quorum. Welcome to the meeting of the Bills Committee on Wild Animals Protection Amendment Bill 2023. This is our first meeting. Item 1, meeting with the administration. Let's invite the administration to come in. Let me welcome the administration to our meeting. The administration will take the floor and brief members on the bill in a moment. Now, members, if you want to ask questions, please press the button now. Since we're all ready, I will give the floor to the administration to walk us through the bill. Good morning, Chairman, members. The administration would like to brief members on the Wild Animals Protection Amendment Bill 2023. There are a number of major proposals in the bill. First, to expand the scope of the feeding ban of wild animals to cover feral pigeons. Second, increase the maximum penalty for illegal feeding of wild animals and feral pigeons. At the same time, a fixed penalty system will be introduced. Third, will broaden the scope of enforcement officers. They will be empowered to demand personal details of persons suspected of committing the relevant offenses. This bill is a response to our last exercise at the end of last year. That is, we expanded the feeding ban area under the Wild Animals Protection Ordinance to the entire territory of Hong Kong. At the time, we received views from LegCo members and the public. There were calls that the feeding ban should be applied to feral pigeons as well, on top of wild animals. That's the background of this amendment bill. Thank you. We welcome questions and comments from members. Thank you. I thank the administration for their introduction. They explained the work of the Bills Committee and the bill to be examined. Members, you will now have the floor to make comments, and then once the Q&A session is over, we'll start the clause-by-clause scrutiny. 7 members in total have indicated their wish to speak. Each will have 3 minutes. We need to make time for the scrutiny of the bill. Stephen Ho will kick us off. Thank you, Chairman. I welcome the administration's expansion of the scope of a feeding ban to cover feral pigeons, and the DAB welcomes the same. However, we discussed how enforcement action should be taken, especially in public housing estates. Unlike wild pigs, for feral pigeons, there may be even more conflicts, as it would be easier to take enforcement action in housing estates. So this is a question for the administration on collaboration among government departments. Some offenders may be feeding feral pigeons within housing estates. So how will you take enforcement action? And there are different ways of feeding. We witness people deliberately dropping stuff on the floor. For example, they may make a hole in a bag, and as they walk by, the feed will just drop from the bag for feeding. How are you going to enforce the law? Also, For housing estate or public housing estate residents, some of them put the pigeon feed on the top of the air conditioners or the air conditioning windowsill. How do you tackle these problems? This is an environmental issue. How are you going to work with the AFCD and other government departments in changing the habitats of feral pigeons? For example, not far from the feeding point A, a feeding point B should be set up so that the pigeons will be diverted to move elsewhere, away from the residential neighborhood. This is one way to tackle the problem, because otherwise, simply by law enforcement alone, this will imply a lot of enforcement resources. So 3 questions. Thank you, Mr. Ho, for the questions. Before we drew up the bill, we received a lot of invaluable views, in particular on the effective enforcement of the requirement. The AFCD has all along been working closely with the FEHD and other government departments for the sake of effective enforcement once the bill has been passed. Now, I will give the floor to the AFCD representative before I supplement the answer. On law enforcement, the AFCD and other departments such as the FEHD, Housing Department, and the LCSD take joint enforcement action depending on where it is and which department is responsible for enforcement. For private premises, the AFCD is responsible. For parks, so on and so forth, the LCSD is responsible. For public housing estates, the housing department. A risk-based approach will be taken when it comes to law enforcement. Resources will be deployed so that we act on intelligence and take enforcement action on the selected places. We are in the process of drawing up a set of enforcement guidelines so that law enforcement officers at the front line can follow the guidelines to ensure a standardized approach to enforcement. Joint operations will be mounted to tackle the difficult spots such as housing estates, private property. If we are required to take law enforcement at these places, we will launch investigation and take follow-up action. We'll also join hands with the property management companies. All right, what about the various means of feeding? Can you tell us more about the guidelines? That is, can you explain about the joint departmental operations? I think this is an issue close to the heart of the public. I'm talking about the various modus operandi of feeding, such as poking a hole in the bag for the feed to be dropped onto the floor, so on and so forth. For someone who keeps on feeding feral pigeon at a place, like Mr. Stephen Ho said, these people may deploy different tactics. So law enforcement officers will be sent to the place to observe the situation and note the frequency, the types of feed, and how pigeons are fed, etc., before we take law enforcement action. We take different approaches on a case-by-case basis. Well, I think what Stephen Ho said is that the offender is not going to admit the act of feeding, but then in the course of committing this act, the food for pigeon may be dropped on the ground such that the pigeons will be able to consume the feed. Well, let me supplement. It depends on the evidence available and the circumstances at the time. What I need to add is that the law enforcement officers will consider the modus operandi of the suspect. For example, if the feed is dropped from the bag, then the officers may observe whether this happens a few times a week as a factor of taking enforcement action. About this feeding ban for feral pigeons, now if somebody discards food in a public place, then the act itself is littering. It is an offense. As I understand, the maximum penalty has been increased to $3,000, which is a strong deterrent. Mr. Kitson-Yang. Yes, at the district level, feeding of feral pigeons is a major public nuisance and environmental hygiene problem. It is really common. So I welcome this bill so that more public officers will be authorized to take enforcement action. But one major obstacle in tackling this problem is a lack of enforcement officers. There aren't sufficient officers. Like the administration explained, you can prosecute the offender for littering in the first place, but we need to find out where and when this person is feeding feral pigeons. Even with all the information available, once we inform the FEHD, this person is still allowed to go scot-free. Now, if you don't take rigorous enforcement action, the problem of feeding will just continue. So it's about increasing enforcement manpower. You need to, for example, take an electronic means of enforcement. There may be a group of feral pigeons gathering somewhere, and surely this is a black spot. They have a habit, after all. So if you don't have sufficient staff to take enforcement action, you should do it electronically. Because we have been reflecting the situation to your department, but so far the problem remains unresolved. In the past, there were some kind of enforcement actions, but they were not effective. Now different department staff, including the housing department, will be delegated to take enforcement action. Now, of course, at the moment, the housing department can also seek help from the AFCD, but there likewise aren't sufficient staff of the AFCD. So the crux of the matter is to increase your enforcement strength. I will just briefly take this question, and then I will invite Mr. Chan to answer the question on manpower and deploying technology to expedite law enforcement. As Mr. Yang mentioned just now, the proposal in this bill will allow not only the AFCD but other government departments to take law enforcement action. What about other departments or public bodies such as the MTRCL? Now, it is not included in the bill, but I stress, for example, that the MTRCL has their own bylaws. Now, the bill doesn't make it explicit that staff of the MTRCL and other public bodies can take enforcement action. However, they can also participate in the process by providing information to the AFCD to facilitate their enforcement. In order to enhance the efficiency, we have included this proposal in the bill, and that is we have increased the amount of fixed penalty for illegal feeding, and this can substantially increase the effectiveness of law enforcement. I will now give the floor to Mr. Chan to explain the use of technology.
Thank you. Thank you, Mr. Yang, for your comments and suggestions. In relation to enforcement, we will conduct joint operations with other departments. We will also make use of technologies, for example, CCTVs, cameras, especially in the black spots. That should help us monitor the situation at the black spots. We can then make appropriate arrangements to take enforcement action. The legislative amendments include a feeding ban of feral pigeons. Apart from that, we have increased penalties and introduced a fixed penalty regime. We believe there will be greater deterrence. And when taking enforcement action, we believe people will be deterred from feeding feral pigeons. Next, Mr. Lam Chen Sing, please. Thank you. In the paper and the bill, it says that there are officers from 3 departments that will take enforcement action. Apart from the AFCD, there will be the Housing Department, the Food and Environmental Hygiene Department, as well as LCSD. I want to know about the grades and positions in particular that will be taking enforcement action. For leisure manager, I believe it says that for that grade, some would have to take enforcement action, but for some leisure assistant, they do not have the powers to conduct enforcement action for certain sections. So for staff members of that section, will it be harder for them with the additional workload? That's why I want to know more about the manpower arrangements. That's my first question. My second question is, as other members said, after the enforcement of the law, there will be new challenges. This is different from littering because this is a new offense, so to speak, and there may be disputes between enforcement agents and members of the public. Some may say that their children accidentally dropped the food, or they may say the bird in particular is not a feral pigeon. I can see that there may be disputes. And I understand that FEHD staff members have 800 cameras, body cameras, for them to bring when they are taking enforcement action. Will you consider doing that for this arrangement? And will you provide a grace period of probably 3 months for members of the public to adjust to the new law? So these are my 2 questions. Thank you. The administration. Thank you for your questions. We did consider implementing a grace period. When we extended the feeding ban area to cover the whole territory, we did have an informal grace period where we would just give advice to the members of public. I'll now let Mr. Chen answer the rest of the questions. Thank you. We will set out the authorized officers with the relevant departments. I believe the staff members involved would be those who have already been taking enforcement action, especially for the FEHD, that is those that have been dealing with littering. Apart from promulgating enforcement guidelines, we will provide training to the relevant staff members, as this is a new law or regulation. That's why we will promulgate the enforcement guidelines and provide training. As for whether we will ask staff members to bring body cameras, we will consider that. Thank you. Next, Mr. Dennis Leung, please. While he's away, let's have Mr. Chen Hofeng, please. Thank you, Chair. I think most members of the public welcome the feeding ban of feral pigeons. Last year, we have passed the laws in relation to the feeding of wild pigs. The fine for the feeding of wild pigs is $10,000. Why is this only $5,000? In relation to enforcement, many members have mentioned this. But I want to say that if you have unclear guidelines, members of the public will be confused. Will you make the guidelines public so that members of the public know in what kinds of situation will they be found to be feeding feral pigeons? For example, in Central and Western District, some firms may not be aware that rice has been dropped onto the ground. Will they be charged? And in fact, you do see that a lot in the Central and Western District for the shops that sell rice. So can you provide more guidelines, clearer guidelines, so that members of the public will not breach the law inadvertently? Thank you for your questions. In relation to the fine, the $10,000 fine is the maximum fine by way of an issue of summons. We have increased the fine from $10 to $100,000. That's for the issuance of summons. Apart from the issuance of summons, we have introduced a fixed penalty regime. Then the fixed penalty is $5,000. So there are two different things. I'll let Mr. Chen talk about the rest. Regarding the enforcement guidelines, the guidelines will be internal for reference of the relevant staff members. Before the enforcement of the law, we will conduct publicity activities to tell members of the public about the new law. We will ask them not to feed wild animals or feral pigeons and what would constitute a breach of the law. In relation to enforcement, regarding what you said for the shops that sell rice, we will definitely observe what the intention of the relevant individual is and whether there are wild animals or pigeons that come to eat the rice. It really depends on the actual circumstances. If they intend to feed wild animals or feral pigeons, we'll take follow-up action. Next, Mr. Lai Tong-kwok. Thank you, Chair. I have several questions. 1. In paragraph 5, you say that this is to prohibit the feeding of feral pigeons. What is the definition of feral pigeons? Administration, please. Thank you, Chair. Feral pigeons, we would refer to rock pigeons, and feral pigeons would be domesticated pigeons. After rock pigeons have been domesticated, they are released to the wild. That's why they become feral pigeons, but then they are domestic in nature. I can see that the Chinese company common names include feral pigeon, domestic pigeon, and rock pigeon. So is it that all live pigeons are covered under the bill as feral pigeons? Chair, administration, please. feral pigeons refer to rock pigeons predominantly, that is domesticated rock pigeons. But under the category of pigeons, there are many different kinds of pigeons that are also wild birds. And they will be classified under wild animals, so the ordinance would cover these wild birds as well. It's just that domesticated pigeons do not classify as wild birds. That's why we want to include them specifically in the bill. Chair, I have a question. How will enforcement agents be able to tell whether the specific pigeon they see is included under the ordinance? What knowledge do they have, or how can they tell that these pigeons they see are those that cannot be fed? You say that some can be fed and some cannot. In relation to enforcement, in order to ensure effective enforcement, you need to talk about that so as to avoid any potential disputes. So can you tell us what you're actually going to do to make sure that won't happen? Right now, in the ordinance, wild animals, including wild birds, any kind of wild birds, and with this bill, feral pigeons will be subject to feeding ban. Once this comes into effect, should you see any birds, they can't be fed unless they are domesticated, for example, chicken or ducks. Then they will not be subject to this ban. For all other birds that the enforcement agents see, whatever they are, feral pigeons or wild birds, they won't be subject to the feeding ban. Well, can I follow up? You can ask the questions in the second round. Ms. Doreen Kong, please. Thank you, Chair. I have reservations after hearing what the administration said to answer the relevant Mr. Lai's questions. So since wild birds have already been included, why are you introducing this bill? Thank you for your questions. The existing legislation is that the feeding of wild animals is prohibited, but for feral pigeons, they are not classified as wild animals under the legislation. That's why we have included feral pigeons in the legislative amendments. I'll let Mr. Chen give some supplementary information. Well, for the Wild Animals Protection Ordinance, there is a definition for wild animals that is those classified at common law to be domestic in So domestic animals will not be included in the purview of the legislation. That's why the feeding ban is not imposed on feral pigeons. We have now included feral pigeons in the legislation. I do understand now.
Chairman, another question. Now, what if somebody is feeding a feral pigeon? Then when the enforcement officers charge at that suspect, then the pigeon definitely will fly off. The AFCD, police, FEHD, housing departments, how will you make sure that all these officers will be clear about exactly what species that is? Because you won't be able to take a picture of the pigeon which has just flown off. It's about evidence. the officers will observe whether this person is feeding a feral pigeon or wild animal. We don't need to catch that animal to take enforcement. Chairman, I am gravely concerned. If I'm not mistaken, when it comes to pigeons, we should refer to Schedule 9. So first of all, if you cannot ascertain whether this is a pigeon, then you cannot apply this bill. So the first point is to ascertain whether that bird is a pigeon. It's very important. I'll wait for another round, Chairman. My time is up. Any response from the department? Guidelines and training will be provided to frontline enforcement officers for them to familiarize themselves with different wild animals and pigeons. Like feral pigeons, we will provide training for them to differentiate between feral pigeons and wild species. For feral pigeons, they are quite common. They should be able to spot them. Ms. Elizabeth Quat. I don't think it's that difficult to tell whether it is a pigeon or not. Well, with AI and with technology, you can just take a picture and find out there and then what kind of pigeon it is. I don't think this is difficult. The point is the government should apply technology more widely. I support this bill because at the district level, over the years, I've received lots of complaints about the feeding of pigeons. Some are repeated offenders. You may slap a fine on them. They just treat it as the cost of feeding pigeons. Your proposal is to increase the maximum penalty to $100,000 and imprisonment term for 1 year. I think this is deterrent so that they understand it's not just about paying fines. They may be imprisoned. What about those who feed pigeons on the balcony or windowsill outside of their flat? Some pigeons may therefore gather on the exterior of buildings at height or just sitting on top of the air conditioners. Now, for residents in Cheung Kwan O, sometimes they find it hard to open the windows because otherwise the pigeons may come in. And there is also the hygiene issue of having bird droppings outside of the windows. So about feeding feral pigeons on the windowsill, how are you going to take enforcement action for private property? Mr. Chan, in drawing up this bill, we considered how enforcement of the law should be taken in private property. Indeed, it is difficult, especially for residents feeding feral pigeons on their windowsills. Apart from gaining entry so as to gather evidence, but that depends on whether the suspect is willing to cooperate. We will also work with the property management company and enter the flat of the complainant. Perhaps the complainant lives downstairs, so as to gather evidence. We will also mount surveillance in a form of perhaps closed circuit TV to our camera to see that whether the feeding of feral pigeons is a common and frequent occurrence in this flat. It depends on the circumstances of the case and whether evidence can be gathered. We will work with the neighboring units as well as the property management companies and we believe we will be able to enforce the law. So that means you will be able to gather evidence without actually entering the flat of the offender. That's right. We envisage that it may be more difficult to gain entry. Now, very often these offenders may just put the feet on the windowsills outside of their flat. They may not mind the presence of pigeons, but they may cause a hygiene problem for those living downstairs. So perhaps we will enter the flat of the neighbor downstairs and point the camera at that flat and see whether evidence can be gathered. Of course, the issue of privacy will have to be addressed as well. Does it mean that the police will take enforcement action with you as well? Yes, the police are one of the parties to be authorized, and if need be, we can mount joint operations with other government departments. I want to emphasize that through this bill, we will step up deterrence by increasing the maximum penalty. We want to make sure that the repeated offenders will stop their behavior. For more serious offenses, we will deploy different tactics, which includes joint departmental operations. Next, Mr. Dennis Low. Thank you, Chairman. This bill stems from our last exercise last year. That is, we amended the 1999 notice. We expanded the feeding ban area for wild pigs in the last exercise, and then we discussed the issue of feral pigeons. The administration heeded our views, acknowledging that this is a problem. The administration has decided to amend the ordinance by introducing this bill to tackle feral pigeons as well. I appreciate the administration's effort. Well, there is more to be decided, however. As you know, for civil servants, they work from 9 to 5. What about non-office hours? How do you make sure that sufficient manpower will be deployed to take enforcement action in those hours? Second, I understand that your officers may take action only once after a complaint has been received. Now, will the frequency be changed so that they go out more often to catch the culprits? Not just once. The third point is this: delineation or boundary. What happens if somebody feeds feral pigeons right on at the boundary of the areas falling under the respective government departments? I don't know whether to call it a lawless zone. What happens if the offender places the food right between the two respective boundaries or areas? How will you tackle the situation? Now, on law enforcement, we don't just act during office hours. For non-office hours, if need be, we take enforcement action as well. For example, we tackle the issue of wild pigs at night. Some offenders would feed wild pigs in the small hours or early morning, like 5 or 6 a.m. So we take enforcement action in non-office hours, and for complaints, we consider the locations concerned and authorize respective officers to take action. Like Mr. Leung said, for example, if the location falls just between two areas, we can take a joint enforcement action so that wherever it is, a government department can take action. Next, Mr. Paul Chair. I have a few points to make. I think it's quite difficult just to allow members to speak up to 3 minutes. Please exercise discretion, because if I wait for another round, I may be repeating the same points, and this will take up half of my time. So if there aren't many members speaking, please exercise discretion and allow a longer speaking time. See, I've used up half a minute. For members who are experienced, we have definitely received complaints of this nature. Now, if the law is getting more stringent, you need to think about law enforcement. Some members suggested taking DNA samples, but it's a question of whether this can result in proper findings. Can you tell us how many cases involved a summons being issued and the department taking the case to the court all the way till the court gives a verdict? Or is it just penalty tickets in general? What about tourists in country parks, in reservoir areas? We mustn't be too restrictive. Now, put ourselves in their shoes. When we visit other countries, we sometimes may feed the birds in these tourist spots as well. So you should educate the public and consider this factor before introducing this bill. Now, you are expanding the feeding ban area to the entire territory, including the window sills of private property. So it's a much wider scope. Now, the AFCD, Housing Department, LCSD, FHD, Police, all of these government departments are authorized to take action. So it's a government level mobilization, like the district council election. Isn't it a nuisance for the public in the first place? And will it become more difficult for government departments to take action? Just to respond to the 2 points made by Mr. Paul Chair, Mr. Chen can supplement the statistics later. Case figures, they serve as a reference. But what happens in this bill is that we are proposing to increase the maximum penalty. So in the first place, for the act of feeding feral pigeons, because of the new penalties, their behavior should change. In the past, instead of arguing the case in court, they may decide to just pay a fine because the level of fine is lower. On this occasion, we propose an increase in maximum penalty along with public education so as to drive a change in people's behavior. Next, on the point of tourists, we need to strike a balance. As pointed out by other members just now, this bill is a result of a response to calls from the community, from the perspectives of improving environmental hygiene, protection of wild species. We need to take this bill forward. On tourists, we will work with the Hong Kong Tourism Board and other relevant associations so that we make sure tourists are included when we disseminate information to the public. Just now, some members mentioned about the transitional arrangements. We keep all options open.
Mr. Chen. Well, the defenses to past cases, they are close to nothing. Often we would just issue summons and the amount was relatively small, a few $100s. That's why we did not often have people disputing liability. We have now introduced the fixed penalty of $5,000. They can raise defenses, the relevant individuals, and then they can speak their cases in courts. With the feeding ban on wild animals, last year we did consider the case that tourists would feed the wild animals, and before tourists would sometimes go to Kamshan to feed monkeys. This is all along prohibited. That's why we have been implementing promotional campaigns in boundary control points to warn tourists not to do so. Thank you. Next, Mr. Paul Zhe, please. The feeding of feral pigeons would cause nuisance. That's why I support the bill. Members are concerned about the enforcement aspect of things, whether they have the appropriate equipment or cases that they may encounter. For example, when people do not produce their proof of identity for the issuance of fixed penalty notices. I hope that the administration has these scenarios in mind, because it was often the case that the staff members could not conduct enforcement on their own and they would require the police's assistance. As the chairman pointed out, it is important to conduct publicity activities to make sure the public knows that this is wrong and the relevant penalties. Of course, if we have to take this to court, that it will not be ideal. I can see that in paragraph 6, it does mention the maximum penalty is $100,000 and an imprisonment of 1 year. This is, of course, very frightening. Can you explain why you set this maximum penalty? Have you drawn reference to the laws of other jurisdictions? My second question relates to the fines. For example, for the fines of littering, it would amount to $3,000, and the fixed penalty for this offense here is $5,000. Of course, it would depend on the circumstances. For example, for a case that may be either littering or feeding of feral pigeons, or in fact, how are you going to distinguish the two? And how are you going to tell your enforcement agents how to distinguish between the two? Or can one be charged for both littering and the feeding of feral pigeons? Administration, please. In relation to the penalties, we have drawn reference from the fines of littering, which is now $3,000. The feeding of feral pigeons will not only cause a nuisance, while environmental hygiene cause a public health hazard, it also causes an ecological imbalance. It's just like the feeding of wild pigs, how it has caused the wild pigs to change their behavior and become more aggressive. That's why we have set the fixed penalty of feeding of feral pigeons to be $5,000. Before, with the issuance of fixed penalty notices, the highest amount would be $10,000 for the feeding of wild animals. As I said earlier, because it would cause an ecological imbalance, that's why we had a $10,000 fixed penalty. When we have thus included the maximum penalty to be $100,000, that is to tie in with the maximum penalty for the feeding of wild animals, because it would cause an ecological imbalance. We thus consider the maximum penalty of $100,000 and an imprisonment of 1 year to be appropriate. As for whether someone's act will be charged for littering and or the feeding of feral pigeons, the enforcement agents would make a judgment based on the circumstances, including what is being fed, the amount of food, whether there are feral pigeons present there to eat such food, and we will also need to make a specific judgment as to whether it is just littering or feeding of feral pigeons. If it is something very ridiculous, if they are dumping several bags of bread, even if there is no feral pigeon there, we may issue a $5,000 fixed penalty notice. If there are no feral pigeons present, we will issue the 3,000 fixed penalty notice for littering. Is it the case that it's either or? Well, it's not the case. It will, if should there be any confusion, we will consult the Department of Justice. Certain individuals may dump the packaging. It is not just the feeding of feral pigeons. It will be reasonable to think of it as littering as well. That's why, based on circumstances, we may consult the Department of Justice for that. All right, I understand what the administration is saying. I'll now let members ask the second round. Again, 3 minutes per member. The first one would be Mr. Lai Tong Kwok. Thank you. I'm following up on the question that I asked. In order to effectively enforce the bill, we need to make sure frontline officers know that whether the relevant individuals have indeed breached the law. According to what the assistant director said, it would constitute an offense as long as someone dumps food on the ground. The administration never defined the term feeding. For people who have put their bread there, that would be littering. And then if there are feral pigeons that come here to eat the bread, would that constitute the feeding of feral pigeons? Also, you said that all kinds of pigeons would be classified as wild birds or feral pigeons. And you said that some animals that are ordinarily kept in captivity will be exempted. So if there are birds that have come and eat the food, how will you know that whether these pigeons are ordinarily kept in captivity? Do the relevant staff members have the capacity to make such professional judgment? I understand that before enforcement agents issue fixed penalty notices, they need to know clearly the acts they see have indeed breached the law. They must also have sufficient evidence to support their decision to issue fixed penalty notice. Can the administration tell me that they think what they have in the bill will indeed not cause difficulties for staff members? I think that what they have right now will cause great difficulty for the enforcement of staff members. Chair, the administration, please, and can you talk about for those birds that are originally kept in captivity, if they have gone astray, what will you do with them? Thank you, Chair. Well, for the term feeding, it is defined in the relevant legislation. Before, there have been precedents in courts as well in relation to the definition of feeding. We will draw reference from the actual circumstances, and I believe enforcement agents will then make a judgment based on the relevant circumstances. The AFCD have taken enforcement action against the feeding of wild monkeys and wild birds before. So birds, the enforcement against birds is not new to us. It's just that we have now included feral pigeons in the legislation. So our officers are already quite familiar with taking enforcement against birds, and they, as I said, will follow the guidelines that we will promulgate. We will definitely review the relevant guidelines and provide the training necessary for the enforcement of staff members. In relation to being kept in captivity, it means that animals cannot enter or leave freely, and they will be taken care of by humans. That would usually be pets or animals kept in farms or zoos. For other wild animals, normally they are not kept in captivity, such as wild monkeys and wild pigs. If they are to be kept in captivity, it would require a special permit issued by the department, and usually we will not issue these permits. If one has to keep feral pigeons, one would have to follow the requirements under Chapter 139L to obtain a permit from the director of the department to keep feral pigeons. So what you see on the street are not the pigeons under the legislation. In relation to feeding of feral pigeons, these feral pigeons would not refer to those that are kept in captivity. There are many people who keep pets, and they are animals kept in captivity. For example, a pet turtle or a pet parrot. That would be different from feral pigeons. How can you distinguish a feral pigeon and an ordinary pet pigeon? Again, for the keeping of that pigeon, it would require 139L. Because often we would need these pigeons will be outside flying for free, and racing pigeons will not be found in the wild in general. Thank you. Ms. Doreen Kong, please. I understand that for certain feeding of pigeons, it would cause a nuisance in relation to environmental hygiene. I do understand that. I think my biggest concern is with the drafting of the law itself. I am worried about Schedule 9. It is a new schedule. It sets out in great detail the relevant requirements. Of course, I understand that feeding of feral pigeons is prohibited in many places of the world. I can see that in Schedule 9 there is the demand notice, the payment notice, and if one does not produce proof of identity, one may be subject to imprisonment. I, having read Schedule 9, think that ordinary members of the public will not understand what they mean. For example, if they do not raise an issue, they will be subject to imprisonment. For example, in Singapore and Vancouver, they have similar feeding ban, but they do not have the law drafted as complicated as we have here. It is also said that a review can be raised. How can you make sure members of the public know how the mechanism works?
Has the administration considered public education? How are you going to educate the public about their rights? Schedule 9 is so complex. There is a whole set of regime for review, for raising objections. Are you envisaging a lot of objections? Otherwise, why the need for Schedule 9? Around the world, I don't see any other jurisdiction with such a complex procedure for banning the feeding of wild animals. This is so complex, and the public may not understand the Schedule 9. They may be inadvertently caught by the law. Is that the desirable consequence? Let me just very briefly respond to your point. Mr. Chan can supplement. First of all, I thank Ms. Doreen Kong for the questions. For Schedule 9, we've made reference to the Fixed Penalty Public Cleanliness and Hygiene Ordinance, or Public Cleanliness and Obstruction Ordinance, which carries a similar schedule. Schedule 9 here is not something new. So that's about reference. Second, Ms. Kong asked whether a defense will be available. I think that it should be interpreted this way. Mr. Chan can supplement on public education in a moment. I will explain from another perspective. As far as this mechanism is concerned, a defense is available. So if a government department issues a notice to the member of the public whom is opposed to this notice, an avenue should be provided for the aggrieved to raise objection, hence Schedule 9. When we come to the clause-by-clause stage, we'll be happy to address other concerns raised by Ms. Kong. Thank you. Chairman, the point is really complex. I haven't compared Schedule 9 to other schedules in other pieces of legislation. At least I think the administration should give us a reply in writing, setting out very clearly the procedures to follow under Schedule 9. This is good for public education. Yes, definitely. Next, Mr. Paul Chairman. To pick up on the same point, I understand Ms. Doreen Kong's concern. But at the same time, I think that people are used to this mechanism, such as for drivers, they may receive a notice demanding the particulars of the driver to be proffered, and you need to make a correspondence with the administration. Anyway, to pick up on my last thread, what is the average fine meted out by the court? Since you answered that normally nobody would contest the case in court. For this year, the average fine was $669. Well, that's a really small amount. Members of the public may not wish to take the case to court anyway. In the future, with a maximum fine increased to $100,000 and imprisonment for 1 year, some offenders may decide to engage a legal representative. So you need evidence, you need the exhibit as well. For exhibit, would you need the pigeon itself? Now, according to some experts, you can take a DNA sample? Or is it that taking the picture or video of the pigeon would suffice? In case somebody pleads not guilty in court, I want to know the chain of evidence. We shouldn't think that as impossible, because from the public's perspective, from tourist perspective, we may not want to make it too difficult for everybody, because there are already so many restrictions in Hong Kong apparently. Will Hong Kong become a police state to some? I just want to make sure a proper balance is struck. I understand there is a need to take law enforcement action, but the balance is as important. About the definition of the common law is convoluted. According to the common law, feral pigeons are not classified as wild animals. And then you have this list of rock pigeons, feral pigeon, domestic, or rock pigeon. So I just want to make sure you have thoroughly considered your scheme and find it to be feasible. On enforcement, we are taking enforcement action, and we have been doing so for many years. For example, about the feeding of wild monkeys in Kam Shan Country Park. And I'd say that we are required to gather sufficient evidence, including, for example, an observation of the person actively approaching the area, placing food there for feeding, the frequency of doing so. We need to make sure that we clearly observe these things before we issue a summons. Now, at the moment, there is no avenue of a fixed penalty. Every offender is required to attend court after a summons has been issued. But nobody argued the case in the court, right? Yes, at the moment. But in future, it may not be as easy for you if the case is taken to trial. I mean, the court has handed down guidelines for our reference on gathering evidence as to what evidence we need in order to substantiate this claim. The definition of the wild animal under the ordinance, that is a Wild Animals Protection Ordinance, is any animal that are not wild, not domesticated. And we are putting a list here: feral pigeon, domestic pigeon, or rock pigeon. They may call this kind of pigeons different names, but they just fall under the same category of rock pigeon. They are feral pigeons that have been domesticated. I see that two more members would like to speak in another round. I am going to allow that. But let me remind the administration at the same time that members are mostly concerned about enforcement after the bill has been passed. And I don't think members are convinced. They are not very confident. Some members ask whether you have conducted a trial run of the enforcement exercise. Members ask questions on different topics. The acts of feeding involve dropping food on the ground, feeding right from your own premises, placing food on the windowsills, etc. You need to continue to conduct drills to make sure that the enforcement action will be effective. Otherwise, our members won't be confident enough in scrutinizing this bill. you may not be able to reduce the occurrence of feeding simply by increasing the maximum penalty. We want to make sure that there is real deterrence. By raising the maximum penalty, we all hope that you can truly tackle this problem. Rolling out this bill is not the end of your work. Two members would like to speak for another round, so I'm going to allow a third round. Each member will have 3 minutes. Mr. Lai Tong Kwok. Thank you, Chairman. Picking up on the last point, Deputy Secretary told us that there is a definition of feeding, but I'm sorry to say that I don't see this definition in this booklet here. Please help me find this definition. Second, the assistant director told me that there is case authority. What case authority was he referring to? Is it a ruling made by the Court of First Instance, District Court, or Magistrates Courts? Because I heard the fine meted out being several $100s. I suppose this is a case concluded at the Magistrates Court. We must bear in mind that the Magistrates' ruling is not binding. The ruling applies only to that court itself. So without a proper case authority, there will be problems in the future. Like Mr. Porcher said, it may be all right for a defendant to pay several $100s of fine. In the future, not so. If you raise the maximum penalty to $100,000. So it's all about the effective implementation of the bill, and that hinges on whether this bill is clear and beyond doubt, and that law enforcement officers can fully grasp what he is required to do in order to put forward or adduce sufficient evidence so that the prosecution can prove the case beyond a reasonable doubt, which is the onus on the shoulders of the prosecution, or else you will lose in court. I ask about pigeons for raising or pigeons for food. For pigeons for raising, they will be released to fly a race before they are put back in the cages. So how do you exclude this possibility of people using pigeons for raising? If you are not able to address this point beyond reasonable doubt, you will lose in court. And it may be all right for you to just let off one defendant, but if it becomes a precedent, then the bill will become toothless. So the administration should go back and consider improving the clarity of the bill so that members of the public are well aware of the circumstances under which they may be breaching the law.
Any reply from the administration? Thank you for the questions. Of course, we understand that the legislation has to be clear. We said that feeding is already included in the existing legislation. For the other points, I'll let Mr. Chen address them. In relation to pigeons raised for food, in general, the pigeons raised for food would require a permit to keep, and people won't just release them into the wild. As for whether the pigeons being fed are pigeons raised for food, we will have reference to the circumstances. We will need to ask them to prove whether these are pigeons raised for food. If they are not, we will take enforcement action. And then that individual would have to raise a defense to dispute liability. Excuse me, Chair. I think the Assistant Director was confused about the standard of proof. The prosecution has to prove beyond reasonable doubt that the individual has committed an offense. That's the individual themselves won't have to raise a defense. That's why if you have insufficient evidence, the case won't stick. This is a prevailing principle in Hong Kong's legal system. In criminal cases, defendants do not have to raise effective defenses. It requires the prosecution to prove beyond reasonable doubt the offense. I would like the administration to provide a definition of the word feeding. I do see the word feeding in existing legislation, but I don't think there is a definition. Well, I want to ask the administration, is it the case that feeding is defined in existing legislation? Well, what I meant was the term feeding appeared in the legislation, that is Wild Animals Protection Ordinance, Chapter 170. I do understand there to be no definition of feeding in the ordinance. Can the colleagues from the Department of Justice provide a definition of feeding? Well, according to dictionary definition, it would mean giving animals food. I believe members of the public understand that feeding means giving food to animals. I do understand your concerns, Mr. Lai. We'll take care of that later. Next, Mr. Doreen Kong. Thank you, Chair. The administration said that Schedule 9 refers to the fines and fixed penalties public cleanliness regulations. I will compare this Schedule 9 to the procedures in the ordinance, but from what I see now, there are some differences. It is said here, if people do not produce their proof of identity when demanded, well, under the Public Cleanliness and Obstruction Ordinance, they will only be fined. Under this bill, if one fails to produce their proof of identity, not only will they be fined, they will be subject to imprisonment. This is set out in page 7 of the marked up copy. Why is this harsher than the fixed penalty public cleanliness and obstruction ordinance? That's my first question. My second question relates to enforcement. You have several categories of enforcement officers in the bill. How will you make sure the enforcement will be undertaken in consistent standards? The staff members of different departments come from different backgrounds. Will they have different standards for enforcement? How will you ensure the standards are consistent? Thank you. Administration. I'll let Mr. M answer the part about Schedule 9, and then I'll let Mr. Chen answer the rest in relation to the enforcement standards. Thank you. In the Legal Services Division report, the marked up copy, page 28, Section 14 of Schedule 9 says that upon review, the magistrate may rescind the recovery order, and the relevant individuals can dispute liability. If one does not dispute liability or pay the fixed penalty based on the magistrate's ordinance, the magistrate may impose a prison sentence on individuals. This is consistent with Chapter 570 Fixed Penalty, Public Cleanliness and Obstruction Ordinance. I would say that it is different in Section 4.2. It says that people will only be subject to a level 2 fine. But in the marked up copy, Section 17D3, it says that apart from a level 2 fine, people may be imposed a prison term. So why is this harsher than the penalties in Chapter 570? It is said in the new Section 17D, if there is reason to believe that someone has contravened the law, one is asked to provide their personal details and their proof of identity for the issuance of fixed penalty. And in 18D3, it says that if one does not follow the demand to provide personal details and the relevant this is consistent with the Section 18, that is a level 2 fine and imprisonment of 6 months. If people do not produce their proof of identity under other legislation, people will not be subject to imprisonment. So I'm not asking them to repeat what is said in the bill. I'm just asking them why that is the case. The speaker does not have his microphone turned on. Well, thank you for the questions. In fact, I understand that there is indeed a difference with the maximum penalty in Chapter 570. The reason why we impose this is because if the penalties are indeed the same, $5,000, a lot of people will challenge this. And many people may take this to court. We're concerned that there may be more cases where people would choose to take it to court. That's why we have added the imprisonment term, the 6 months imprisonment. Mr. Porter, please. I understand that pigeons raised for food will require a permit. But for those that are just kept in captivity, so the terms feeding or in captivity, it may be understood by members of the public. But as I said before, as these cases were not taken to court before, people didn't challenge them. But once people take it to court, the definitions may be challenged. If one places food under the canopy or on the canopy for birds to eat, and the birds would just come back to eat them, would they constitute animals kept in captivity? When there is joint departmental operation, that is, it won't just be AFCD. They will work with the police and whatever department. If joint departmental operations are to be undertaken, there are often difficulties. People would just be shirking their responsibilities. So while you are trying to broaden the scope of enforcement officers, will it cause the problem of departments actually shirking responsibilities and saying the responsibility is that of other departments? Well, thank you for your questions. I think in relation to this, we have the relevant guidelines to make sure there is better coordination between departments. We do understand your concerns and we want to make sure the relevant provisions are enforced effectively. As for some terms that are used in the bill, I'll let the Departmental of Justice colleagues provide supplementary information on this. Whether it is in the existing legislation or in the bill, we are trying to make sure the provisions are clear. At the same time, do we really need a definition for every term? I do think that we can really think about that. I'll let the DOJ colleague talk about the definitions of captivity and feeding. Thank you, Chair. When we consider whether to put in definitions of terms in kept in captivity, for kept in captivity, it is found in Chapter 170 as well. Kept in captivity means that animals are kept in spaces where they cannot enter or leave freely. We believe ordinarily kept in captivity should be sufficient in defining the term itself or the meaning itself. Thank you, Chair. I can see that 2 members want to ask for a 4th round. I can see that we still have time. That's why I will open the floor for them to ask questions for the 4th round. First, Lai Tong Kwok, please. I can see in the bill that there are 2 groups of people who have enforcement powers. One would be authorized officers. I believe authorized officers was also included in the existing legislation. The bill has a new term called specified officers. And these individuals are appointed by the director. With these 2 groups of people, I think it's confusing. What is the exact difference between authorized officers and specified officers? What are their respective functions? Are there any overlaps? Is it the case that they have different duties? I want to know specifically why there are 2 different categories. I asked the administration to provide a paper for members' reference, the functions of the respective categories. That's my first question. My second question is that for the authorized officers or specified officers, when they execute their duties, is it the case that they have to perform some procedural work before they conduct enforcement action? Will the procedural work cause them difficulties in enforcement. Thank you.
Right.
I'll briefly answer this question and then Mr. Chan can supplement. For authorized officers, we're talking about AFCD officers and the police, and under Cap 270, they are authorized to take action. For authorized officers, they are tasked to taking enforcement action under the fixed penalty system. So in terms of the scope of power, it's narrower. I would be happy to provide a written response to explain the difference between the two. Mr. Chan can now respond to the preparation work required before taking enforcement action. Be it a specified or authorized officer, this officer will be required to show the warrant card to explain the authority. Is it a card or is it a document in the form of a piece of paper? The authorization comes in the form of a warrant card. So it's like a staff card or a warrant card. So you have specified officers as well as authorized officers. But these officers may not have only a single task on their hand. So that means they need to carry a staff card or warrant card issued by the director. Is that right? Otherwise, without carrying both documents with them, even when they witness the act of feeding of feral pigeons, they won't be able to take a law enforcement action and exercise their duty. Department, is it that the officer must carry the warrant card with them, especially the card showing authorization for this ordinance? Please switch on the mic for this representative at the back row. Yes. The officers are required to carry their warrant cards under Cap 170 in the exercise of their duty. We will also make reference to other ordinances such as 599G. The authorization comes in writing. It spells out the different grades of officers under respective government departments being authorized to take law enforcement action. The authorization is also available online. That means if the officer hasn't carried the document with them, they can go online and retrieve this authorization document. You have other questions? Yes, I will wait for the clause-by-clause scrutiny stage. Ms. Doreen Kong, very briefly, would the administration please tell me the following? Have you made reference to just the fixed penalty public cleanliness and obstruction ordinance or other benchmarks in drawing up this schedule? I just want to consider the proportionality issue. Mr. Lai Tong Kwok just now asked for the definition of feeding. Perhaps I didn't catch it clearly. I was reading at the time. Can you tell me what the most authoritative case authority is? I went on the judiciary to check the case. I couldn't find it. Now that we have a DOJ representative here, please tell us the most authoritative case you have. DOJ representative, are you able to take this question, please? I thank member for the question. We make reference to different pieces of ordinance, such as Cap 570. That's a very important piece of legislation. The other is Cap 599G. We also make reference to the relevant penalties in these pieces of legislation. Now, for the fixed penalty in this bill, we propose to pitch it at $5,000. It's higher than the fixed penalty for littering because of the more far-reaching implications of illegal feeding. As you mentioned, there are also other specific provisions. Those who are uncooperative and refuse to produce the ID card. In terms of the amount of fine, again, we've made reference to Cap 570. We are concerned about the possible challenges in court or people taking the case to court, and that is why we've proposed to include the term of imprisonment as well. As for the mechanism for metering out fines in this bill, I suppose this is similar to that in other ordinances. Definition of feeding. Yes, my understanding is that it is very difficult to set out the definition of each and every term in a piece of legislation. So when the definition of a term is in dispute, how should it be dealt with? Can we just use the general meaning set out in the dictionary? Can you please explain this to members? Yes, in considering whether to provide a definition in the statute, we consider whether the dictionary meaning tallies with what we have in mind. So for this term, captivity and feeding, we consider the meanings in the dictionary. We believe that they are sufficient in helping us interpret the meaning of these terms. So unless we propose a departure from the dictionary meanings, we won't provide additional definition. What about case authority on what feeding means? We will provide this information after the meeting. Yes, tell us whether there is any case authority. I've allowed members 4 rounds. Mr. Lai Tong-kwok would like to speak again for the 5th time. I will open the floor again. Members, if you want to speak, please do it in this round. Mr. Lai Tong-kwok. It is easy to take enforcement action in a public place. What about private housing estates? I am not suggesting that you should enter into somebody's home, but say if you are required to act on complaint, or perhaps in some way you have observed illegal feeding in a private property, how do you enter this private property to gather evidence and take enforcement action? About interdepartmental enforcement action and private property, I think the question was asked just now. Perhaps you can provide a clear answer now again. First, we consider whether there is effective management in a private housing estate. For a private housing estate with a owner's corporation and a property management company, then at the first instance, the AFCD will liaise with the OC or the PMC concerned. Now, if the OC or the PMC is cooperative, then our department will go through the case with them together. If there is a difficulty, then the department is under the ordinance delegated with certain powers. I'll defer to the DOJ. Indeed, it is difficult to take enforcement action in a private housing estate. Now, we keep in close liaison with the PMCs, and usually the complaints will come from residents in the neighborhood. They are nuisanced by illegal feeding. The complainants are willing to cooperate with us in the investigation process. They may also allow us to go to their home to make observation and gather evidence. Indeed, we consider the circumstances of each and every case and devise the appropriate measure. I think it's a matter of authorization. Now, if you feed a feral pigeon, then as soon as this is done, the feral pigeon will just fly away. The whole duration may be very short. So, what happens if the private property management refuses your entry when you want to gather evidence and initiate prosecution, etc.? That's the crux of the matter. Now, say, even if a complainant opens the door for you, you may go inside only to find that the feral pigeon is no longer there. I want to know exactly what enforcement powers you have. I think they answered. They will give you a reply after the meeting. The difference and the respective powers given to specified officers and authorized officers, right? They will give you this information afterwards. All right, members, we've had 5 rounds. If there are no further questions you wish to pursue on the overall merits of the bill, policy-wise, we will start the clause-by-clause scrutiny. Before I do that, let me also consult members on whether there is a need to invite the public to give us views on the bill. Is there a need for a public hearing, or just do it in writing? Mr. Lai, yes, I support receiving written submissions. Mr. Paul Chair, I have reservations. I said more than once that as a matter of convention, the Legislative Council should invite the public to provide their views to us, especially for matters affecting the general public, unless there are special reasons. Since the start of the epidemic, we started to take this closed-door approach, so to speak. Isn't it time to change? Is it the norm that we just rely on written submissions, or can we go by our convention and hold public hearings? I'd like to seek the wisdom of the Secretariat. I don't want to change the practice without a full consultation, and that from now on we only go by written submissions from the public. I will invite the clerk to explain this to you. About inviting the public's views on the bill. At the moment, both written submissions and a public hearing are viable, depending on the committee's decision. I know that they are viable. I want to know whether there is a clear stance adopted recently that written submissions should take priority over a public hearing. Otherwise, we should go by the Council's convention unless there is an urgency or a special reason. I don't see any special stance being taken. Only to say that when it comes to subsidiary legislation, the time frame may be a bit shorter because of the scrutiny period allowed. There may be less time for the committee to hold a public hearing. If it's a bill, there should be ample time for a public hearing to be held as well. Mr. Dennis Lam, I'd like to invite Madam Clerk to brief us on the legislative timetable. This is a positive vetting procedure, is that right? So I think we should allow the public to speak out through our platform. In the past, we received written submissions. We weren't very sure exactly what they were about. Sometimes they provided information we couldn't check online. We should invite them to come to ascertain the accuracy of information to help us grasp what they mean and for the public to understand the policy better. Perhaps we can cast a vote on whether to have a public hearing or not.
I'll let the Secretariat answer this. This is a bill. The scrutiny period would depend on the progress of the Bills Committee. First, we'll have the discussion on policy measures, and then the clause-by-clause examination, and then should there be any amendments, the discussion of amendments. So it does not relate to whether this bill is to be implemented via positive or negative vetting. It only has to be completed within the term. Otherwise, if it is not completed, it will have to start all over. But of course, the administration would always want to expedite the progress. Can the administration talk about the legislative timetable? Thank you, Chair. Of course, we want to expedite the processing of the bill. That's why we do understand that there is public concern. However, that's why we do not. We will keep an open mind whether submissions will be invited or a public hearing will be held. All right, so I'll leave it to the decision of members. I, as the chairman, am okay with and all right with both options. Well, members, you can make your decision. Mr. Porter, please. Sorry, it may sound like I am lecturing you here, but I don't mean so. I think if there are no objections, we should respect the tradition of informing members of the public what is going on. Well, Mr. Lighton Kwok, please. The decision is to be made by members of the panel. Some members think that if we have public comments, it will be beneficial to the scrutiny of the bill. That's why, should there be a vote, I will support holding a public hearing for this bill. Mr. Stephen Ho, please. Of course, I don't mind it being open and a vote will not be required. I think traditions are not always beneficial to be carried over. I think with a decision, I will just leave it to the chairman. Of course, I think when making a decision, I want members' input. When I participated in the Bills Committee of the Child Abuse, Mandatory Reporting of Child Abuse Bill, I participated in 4 or 5 public hearings. So I do not mind holding a public hearing. I just want members' input. Ms. Doreen Kong, please. Thank you. I believe a public hearing is needed because the punishment is relatively harsh, as there may be an imprisonment term imposed. Thank you. I gather from what members said that a public hearing should be held, and that is what we'll do. I will liaise with the Secretariat to see what the arrangements are going to be and the time of the public hearing. Is it the case that we can't go into clause-by-clause examination today? Well, Mr. Stephen Ho, so why don't we go into clause-by-clause examination after the public hearing? Well, that's what I was going to say. Before we go into clause-by-clause examination, as members have various concerns, while we wait for the public hearing to be held, the administration can, with reference to members' views, provide more information for members' reference. I think that with inputs from deputations, it will also be beneficial to the administration with your drafting of the bill. In relation to what members said about the distinction of authorized officers and specified officers, please provide more information to members. Also, with the term definitions of feeding and kept in captivity, please provide examples of court cases where dictionary definitions are used. If there are no objections, I think we will wait until we have a public hearing before we go into the clause-by-clause examination. Should we have a date, members will be notified. Any other business? Do the administration and members have other business? If not, the date of next meeting will be notified in due course. If there is no other business, this is the end of the meeting. Thank you.